The first is that USCIS has said that you cannot require a general degree. They're clarifying this, and this is most of these are already in place, but they're further clarifying them and codifying them so that, again, people can't file lawsuits. So if you as an employer require a general degree such as a bachelor's in arts or an MBA, general MBA, for a position, then that position is certainly not a specialty occupation, because you should require a bachelor's in a specific field. Also, so there's some good points and some bad points about this proposed regulation. So that that it is what it is. So the good point is this point number 2, where they say that even though a specific degree is required, it doesn't have to be a single degree. It doesn't have to be a degree. It has to be specific, but it doesn't have to be a single degree. So you can have a requirement for, say, bachelor's in computer science in a closely related field, such as math, etc. The only thing is that you have to show how it is closely related. So that's definitely a plus, because this can add many occupations into a specialty occupation. So you can do a H1 for many more occupations. This is opening it up. USCIS usually looks at a book called the Occupational Outlook Handbook, which is published by the Labor Department. And in this publication, what happens is, if the industry requirement is a bachelor's degree in more than one field, even though they're related, USCIS will often deny or RFE those H1s and say it's not a specialty occupation because it's more than one field. So this is good, because they themselves are saying that more than one field can be requested. So we can look at the OH and see, maybe it'll open up many more occupations where this might be a requirement, and in the past we couldn't file, now we can file. Also, I think a positive point is number 3, which says, in the past, USCIS would say that, in order to file a H1, all employers should require a bachelor's degree. So in the industry, most employers should require a bachelor's degree. So wherever, again, in the OH, it said that normally employers require a bachelor's degree, but some employers don't require, they would use that to deny the H-1B petition. So they are verifying it now and saying it should be required normally, but it doesn't have to be always. It's very important that every single employer doesn't have to require it, but in general, as long as they require it, then it's a specialty occupation. Number 4 talks about H-1B amendments. We all know that if you move work location, you have to file a H-1B amendment, but this was not codified earlier. It was based on case law. Now they're codifying it again to avoid litigation in this area. They are going to give existing petitions deference, which means that if you already have a H-1B petition and you're filing an extension, they should not be sending an RFE out. If it's the same facts and same petitioner, same job description, they should not be sending an RFE. They've been saying this often in their manuals, in their practice manuals, but they haven't always adhered to it. Now, if they codify it, then they have to adhere to it. So this is definitely a positive. Number 6, they're saying that you have to show that if it's an extension or change of status, you have to show that the person maintains status. So they want documentation showing maintenance of status when you initially file the petition, even before they, or if they request it in an RFE, we usually provide that information, but they want it beforehand. So this is especially important in an F1 scenario, to show that you maintained your F1 status, you went to school, maintained full-time school status, or if you're on OPT, that you worked for the required number of hours. So this is important in that, especially in an F1 scenario. They want to completely eliminate the itinerary requirement, which basically in the past they would ask you to list all the employees that you're going to work for the entire period of the duration of the H1, which is 3 years. Now they're doing away with that. Another important change is number 8, which is your validity period on your H1 Sometimes, especially if you're asking for only 1 year, sometimes employers may only require 1 year. But if the H1 is taking longer than 1 year to approve, and this is often true if it goes into an appeal process and then it gets approved on appeal. So from the date that it was approved, then USCIS will automatically move that to 1 year from the date of approval. In the past, if it was approved and the date was over, then the approval would really become useless because USCIS would not move that approval date forward. So the cap gap benefits for F1, we know that people who file a change of status from an F1 to a H1, they're allowed to maintain status as long as their H1 is pending, or October 1st, whichever comes sooner. So they continue to maintain the status that they had when they were first filed their H1. So if they were on OPT when they first filed, even if their OPT expires while the H1B petition is pending, they'll continue to be on OPT. But the thing is that this cap ended on October 1st previously. Now they want to move that to April 1st of the next year, when the next cap starts. So this is really beneficial because then they will never then fall out of status. Otherwise, come October 1st, if their H1 was not approved by then, they would have to go back to F1 status, take classes, or file a change of status. So it was very messy. So that can be avoided now because the cap gap continues. This is very interesting, number 10. It's actually codifying the ability of a person owning a company to actually file a H1 for themselves. In the past, this was not possible, even though they said theoretically it was possible, but they would never approve these cases because when you own a company, you're doing a lot of administrative work, number one, and that administrative work is not specialty occupation work. And number two, it's difficult to prove that you have a valid job offer. There's difficult to prove the employer-employee relationship. Now they're saying, as per this new proposed regulation, that as long as, even if you own the company, and even if you own more than 50% and you're controlling party of owner of the company, you can still file a H1 as long as more than 50% of your work is specialty occupation, and even if the rest is administrative, as long as you more than 50% of it is specialty work, you can still file a H1. This is a great advantage and a great option for entrepreneurs who want to start their own business and do not have a green card to be able to do so. FDNS visits. This is FDNS. This is the body that conducts audits on your company once the H1 is approved, and you pay an extra fee for this. The $750, $1,500 fee that you're paying is for to fund these FDNS visits. So in the past, you could refuse an FDNS officer and not allow him into the office and refuse answering his questions, etc. But now they're codifying this, meaning that they're making it compulsory. In the past, practically, it was necessary to allow them into your office because if you didn't, then they would just write a negative report and then, your H1 could get revoked. But anyway, they're codifying this. So now you have to allow FDNS officers to enter. You have to answer their questions if they're relevant. So site visits are now something that, is not discretionary. Is not something that is up to you. So that's important to keep in mind. So next time you have an FDNS visit, if this rule becomes final, then you cannot refuse entry. Very important that you have a bona fide job offer now. Even now, if you're filing a H1, last year we saw that a lot of skeleton petitions got approved, which means that if you're a consulting company, you filed without a PO work order, they got approved. But if this new law comes into place where they're saying that H1B you have to show a non-speculative job, and you have to show that you have specialty occupation work available for the petitioner. We don't know to what extent they'll take this. It might be they just want to see a PO and work order MSA for at least 6 months or 3 months. or they might want to see it for the entire duration, 3 years. We don't know, but I would caution you to file your H1 quickly so that you don't get affected by this petition. And even if you do, make sure that you have a backup, that you do have a job offer and you're not filing speculatively, just in case this law moves into place before your H1 gets approved. If it gets approved already, you have no problem. So my suggestion would be to file this year your cap case rather than leaving it for next year, because next year the chances of this becoming rule are much, much higher. And for those companies that operate from outside the country, I know a lot of you are in India and you and other countries, and you don't have a physical presence here. You have a registered company and you're running your show out of India. Be careful, because they have a requirement coming up that you have to have a legal presence in the US, which might mean physical presence in the US, where they can issue a service if needed.
So yeah, on that note, we'll wrap up today's session. And once again, thank you so very much for attending this webinar.